So thank you so much for agreeing to be here today and to talk to the students. Could you kind of give them an idea, or introduce yourself and then give them an idea of what your career was like that brought you to where you are today?
Okay. My name is Rodney Klein, and I provide EEO trainings for employers. I started with the U.S. Equal Employment Opportunity Commission like 100 years ago, a long time ago. And I was hired as an investigator, and I investigated individual claims of employment discrimination. I did that for a while, and then I was moved into what they call systemic investigations, which are like the large class investigations. I did that for a while. Then I was moved into something called the state and local coordinator, which meant that I worked as a representative of the EEOC, the federal agency. I was a liaison between our office and the various state and city agencies and offices that administer either the state civil rights statutes or city ordinances. Then I became what they call the charge receipt supervisor for the San Antonio office of the EEOC, which, as the name implies, meant that my group was in charge of processing all incoming discrimination complaints. And then I got the job as the outreach and education coordinator for the EEOC's Dallas district, which is most of Texas and southern New Mexico. And I did that for about 16 years. That was a lot of fun. I retired at the end of May of 2021, and in June I opened up my own firm, and that's where I got to where I am today.
So could you kind of expand on EEO legislation and the EEOC, maybe their role in the work environment?
Sure. The EEOC was started as a part of the Civil Rights Act of 1964. The Civil Rights Act of 1964, Title VII of it specifically deals with employment. So in other words, an individual should not be discriminated against because of their race, color, religion, sex, national origin. That was the Civil Rights Act of 1964. And the EEOC was created initially to monitor and eventually to take and investigate and sometimes litigate employment discrimination claims in civil court, in federal civil court. Now, that protection's expanded to age, 40 and over, disability, and even genetic information. So the EEOC was created to, in a sense, to be a place for people to go if they feel like they've been discriminated against at work, to have their claims investigated and hopefully resolved. Way back in the 70s, the EEOC got litigation authority, so they could begin processing civil lawsuits on these issues. And so the EEOC is a resource for people to go to for that, but it's also a resource for people to go to, particularly employers and employees, for education. So in other words, to find out about what your rights are and your responsibilities as an employee. But also if you're an employer and you want to understand how the law is supposed to work in a practical sense, what you're supposed to do, the EEOC provides a great deal of guidance in that area. And the work that I specifically did for the EEOC, which is going out and speaking to employers about how they're supposed to handle civil rights within their own workplace.
So you mentioned that you investigate, but that the EEOC also brings forth civil lawsuits. So can you expand on the employee perspective? So the employee wants to bring forth a claim. So for example, a supervisor has an employee that made a claim with the EEOC. Can you expand on that? Maybe the process that would happen?
Sure. If a person is working for somebody, or if they're an applicant for employment and they feel like they may have been discriminated against, they have the right to file a charge with the EEOC and have that investigated. A person has to do that within 300 days from the date they were harmed. So in other words, if I'm working for a company and I'm fired on January 1st, then I have 300 days, or roughly 10 months, to bring that charge to the EEOC. Anything after that, then I lose my due process. I don't have the ability to file a charge or file a lawsuit. A person has to file a charge with the EEOC before they can ever pursue a lawsuit. So the charge goes to the EEOC serves that charge or that complaint on the employer. They do an investigation. And Obviously, there are one or two outcomes to the investigation. Either they didn't find discrimination, and so therefore they dismiss the case and give the individual what's called a notice of right to sue, or basically the agency's permission to them to pursue this matter in federal court themselves, or they issue a finding that says there was discrimination. And if that's the case, then they try to resolve it with the employer and the employee through a contract, through an agreement. If that works, great. If it doesn't, then the EEOC considers whether they will initiate a lawsuit on behalf of the individual and behalf of the public. Anywhere along this process, the individual filing the complaint and the employer can enter into either a mediated settlement or settlement discussions with the investigator. So there's an ability to resolve the complaint long before the agency ever finishes the investigation or gets to that point of maybe looking at litigation. So if you are an individual, that's kind of the process and how that works. Of course, the secondary question I always get is, how long does this take? And that's always the $64 question. Every case is going to be different. Some resolve quickly, some don't. The agency always tries to shoot for an average of about 180 days, sometimes less, sometimes more. A lot of that's going to depend on how complex the issues are, and also just what their workload is. Sometimes at certain times the agency gets a lot of charges, sometimes the agency doesn't get very many, depending on how the economy is going. And sometimes they have a lot of investigators and sometimes they don't have a lot. That's just kind of the nature of being a budgetary organization. And so that will also impact how long it takes for somebody to get their charge resolved.
So if we're looking at the staffing process, we're looking at applicants, and applicants have limited one-sided information. So what type of complaints would you normally see from an applicant, and what type of investigation or evidence would you require of the employer?
Okay, there's a number of different things that we look at in the hiring process. One of the things that the EEOC or that the law looks at is something called disparate treatment or different treatment. And in other words, let's say you and I applied for a job, the same job, and I got the job, but you didn't. And you said, wait, I'm way more qualified for that job than Rodney. I think he got the job because he's a man and I'm a woman. So that's a sex discrimination claim. You file that charge with the EEOC, and the EEOC would investigate that claim to see whether there was any validity to it. That's a disparate treatment claim of discrimination. Now, how do people come? I think you kind of touched on that a little bit. A lot of us, we all applied for jobs. We didn't get them. We had no idea why we didn't get them. We just didn't get them. And so how does somebody know? And I think, to be realistic, when we're talking about hiring, there is a limitation as to what you will know. Now, if you're fired and you think it's for a discriminatory reason, you probably should have a pretty good reason or rationale why you think that was discriminatory, because you're there, you've seen it, you've heard it. You ought to be able to have something to hang your hat on that was discriminatory. But in hiring, that's different, because you don't have access to a lot of information. So a lot of times what you'll see is, for these individual claims, a person may say, I just should have been super qualified for that job and I just didn't get it. And that doesn't make any sense to me. So there must be something wrong here. That's something that an individual may hang their hat on. Or they may say, I just got this icy feeling from the person that was interviewing me that there was something about me that they didn't like, or maybe that the interviewer said something that would indicate some sort of bias. Or sometimes it's as simple as, I walked in there for the interview and nobody looked like me, and I should have been really qualified for that job. All of those things may lead a person to the EEOC to file a claim of discrimination. So from an individual standpoint, those are what those claims are based on. And it's kind of up to the EEOC or the investigator to figure out whether there is any connection to discrimination. So what tends to happen in an investigation is that the individual who files a charge gives their side of the story, right? Which will be what they went through and what happened and why they think there might be a connection to discrimination. then the claim goes to the employer, and the employer gives us their version. And of course, their version is going to say, well, this is why we selected Rodney over Rebecca, right? So this is why we did this. And then the investigation starts from there. So we have two sides. The EEOC will have two sides to the same story. And when I say EEOC, I'm kind of talking universally because there's the state law that's pretty identical to the federal law that says people shouldn't be discriminated against at work. And that's administered by the Texas Workforce Commission Civil Rights Division. And there's some little differences between the statutes. The one that I think is most important is that when I said EEOC, you have 300 days to file. With the state of Texas, you have 180 days to file. So it's a little bit more than half that time period. So you have to be kind of careful with that. But when I say EEOC, I'm really talking about it could be either EEOC or it could be the state of Texas investigating the case. But when they're getting that information, it's up to the investigator to figure out whether there's some connection to discrimination there. And they're going to do that one of two ways. One of ways, or not one of two ways, but to do two different things, to prove two things. One is they're going to be able to compare you and I, right? I got the job, you filing the complaint of discrimination. The investigator is going to compare our qualifications and to see who is the best qualified candidate for the position. So if you file the complaint and the investigator looks at our qualifications and says, Rebecca's, she's a little bit better qualified than Rodney for the job, then that's half the investigation. The other half of the investigation is to prove that I got the job because of my sex. Sex isn't coincidental. It's because of my sex. In other words, I didn't get the job because I'm first cousins with the owner, right? That would be unfair, but that's not illegal. It would be because of my sex. So the investigator is trying to compare and trying to connect to discrimination, compare the individuals and connect to discrimination. That's an individual case. Now, when we talk about hiring, though, there's another aspect of discrimination that's super important. And that's not a disparate treatment case. That's something called an adverse impact case. Now, we talked about disparate treatment. That's going to deal with a very specific animus. In other words, the hiring manager specifically hired me because I'm a man or excluded you because you're a woman, right? So that's a specific animus, an overt animus. Adverse impact doesn't work that way. It works kind of in the opposite way. In other words, it hinges on something called a neutral policy. There's nothing overtly discriminatory about the policy. But by applying that policy, it adversely impacts certain groups of people. Now, let me give you an example. If let's say you're hiring for, because this was like a big case, a precedent-setting case when I talked about adverse impact years ago. Let's say a company's hiring custodians, and they say, well, in order to be a custodian, you have to have a high school diploma. Now, there is nothing that is overtly discriminatory about that policy. In other words, to get the job, you have to have a high school diploma. But in this particular case, that employer was in North Carolina. This was back in the early 70s. And so that adversely impact African Americans in North Carolina because they were much more less likely to have a high school diploma than white applicants. Now, the law says if you're an employer, you can have a policy that adversely impacts certain groups of people if, and it's a big if that policy is job related and consistent with business, and here's the key word, necessity. In other words, we can't get the person we need unless they have the high school diploma. And so the question comes into play is, well, do you really need a high school diploma to be a good custodian? So therefore, it was deemed to be illegal. We get these in hiring cases. And I think if you're kind of thinking along with this, this is what ends up being large class cases, right? Because we're dealing with large groups of people who have been adversely impacted because of their race or because of their sex or because of their ethnicity. That comes into play as well. So we may see this in recruiting. Somebody says, well, our policy is to recruit strictly by word of mouth. Okay, well, what do we know about word of mouth recruiting? that the people you hire or recruit are going to look like the people that are at your organization already. So that may adversely impact certain groups. You may have it in the application process itself or in the hiring process itself. An employer may say, we're going to focus in on hiring or giving preferential treatment to recent college graduates. Well, that is like code for younger people or people who aren't over the age of 40, because if you're over the age of 40, you're much less likely to be a recent college graduate. So the employer would be on the hook for showing that being a recent college graduate is absolutely necessary to doing that job. And that's going to be really hard for an employer to do. One of the things that we run into sometimes with disabilities is something along the same lines. The ADA is very specific about qualification standards. So in other words, what do we see in a lot of job postings? Must be able to, it doesn't matter what the job is, must be able to lift, let's say 30 pounds. Okay, really? Is that a requirement? And so the hiring manager says, can you do this? And it says lift 30 pounds. And the person says, well, no, right? Because maybe they have a disability that keeps them from lifting 30 pounds. And so they're not considered for the job. Well, the ADA says, look, you just made that a qualification, right? If you said the person can't be considered unless they can lift 30 pounds, then you have to show that that's the only way you can do the job is by lifting 30 pounds. The trouble is nobody gets paid to lift. They just don't. Now they may get paid to move a 30-pound box from point A to point B, but nobody gets paid to lift weight unless you're a weightlifter. So that's a qualification standard that may come into question because it excludes people with certain types of disabilities. So that may become an issue as well. So as you can see, there is a myriad of things that may come into play from a discrimination standpoint around hiring and recruiting, whether we're talking about disparate treatment, whether we're talking about adverse impact, or whether we're talking about the creation of ADA prohibited qualification standards.
Have you noticed that there is an impact on trends with social media? You know, what's going on in the social media or in society may impact the types of claims that are made or concerns that are brought to the EEOC?
Not that I noticed. I think, you know, when the Me Too movement started, I don't know that I would really qualify that as social media. I mean, I know social media is involved in everything we do, but I don't know that that was necessarily driven by social media. But when Me Too movement started happening, then we started seeing a large number of cases come in on harassment, especially sexual harassment cases. And so that would happen. But typically speaking, I don't know that we see a lot of those. I don't know that social media really drives those issues. I think in a larger sense, what you see in the workplace is a direct reflection of what you see in society. Work's the one place where we all come together. We all bring our differences with us. We all bring our different outlooks, our different opinions, our different points of view. And so those frictions that are in our society are frictions that we also see at work. And so what I have seen over the years, until up about the time that the Me Too movement started, when I was asked to do training for employers, it was almost always law-based, right? How do we avoid ending up in court? But after the Me Too movement, and then all the stuff that's happened since that time, employers are looking for something different, right? They understand that just focusing in on the law stuff isn't saving them, and it's not really resolving workplace issues, right? Law deals with behavior, but it doesn't deal with the root causes of behavior. So what I've been asked to do mostly since the Me Too movement started about 5 or 6 years ago hasn't necessarily been as law-based as it's been leadership-based or culturally. In other words, how do we create a culture where we have people who are just different, who can figure out how to come together for a common purpose and meet in that common ground and share their obligations with each other and not get hung up on the things that we feel are different about us from other people. And I think that's been a big shift in education. But I don't know I can't say with any certainty or with a conclusion that it's driven charge filings.
I know that sometimes social media preempts risk management, so it preempts training. You know, I see something going on in social media, that's something we need to be concerned about. And so maybe we need to start training on it. Maybe we weren't aware of it. And oftentimes when people see other people like me complaining about things that I've experienced, I feel more empowered to speak up about some type of injustice that's occurred to me. You know, so which is why I wondered why social media, you know, if social media was influencing the EEOC's trends. Also, I've heard you speak before and you've talked a little bit about the strategic plan of the EEOC. Can you maybe introduce that concept and expand on that? How does the EEOC decide what direction they're going and what they're looking for in potential claims?
Yeah, the EEOC from time to time, just to kind of maybe back up a little bit, the Equal Employment Opportunity Commission is actually a commission of people. And so there are up to 5 commissioners that are politically appointed that run the EEOC. You have a chair, a vice chair, and up to 3 other commissioners. They kind of drive the bus. Now, most of what the EEOC does is set by statute and precedent, and it just never changes. But obviously the commission itself, the political appointees, sort of send the EEOC off in certain directions. And one of the things that they do is they create periodically strategic plans, and off of that a strategic enforcement plan, which, as the name suggests, is the type of cases that they want to take a look at. And that changes. And in fact, I think, if I'm not mistaken, the EEOC is set to come up with a new strategic plan, and therefore a new strategic enforcement plan in 2022, I believe. So they're thinking and talking about it. When we talk about the strategic plan, it just basically says we kind of like to focus on certain issues. And so in the last strategic plan, the commission was very focused on serving the people that you would argue that the EEOC needs to serve the most. And those are people that are on the bottom rung of the economic ladder, the people that have the least amount of access to resources. And so we looked heavily at people who were immigrant or migrant workers, people who were in underserved populations, certain aspects of the ADA that we looked at as well. We looked at equal pay issues at that time. And so those were areas of interest to the agency. In a sense, though, you know, it's still all discrimination. So it's not like a person comes to the EEOC with a case that's not in the strategic enforcement plan and they're turned away. That doesn't happen, right? So if they have an issue of discrimination, it's still important. It just is that the agency is looking to maybe focus more of its attention and its resources to looking at certain types of cases. You see this from time to time where issues will come up and the EEOC will be fairly responsive to try to stay in the curve. And so you see this sometimes with the gig economy. The EEOC is taking a look at those kind of cases to see how or if they fit into the civil rights statutes. You see the EEOC looking interestedly at big data and algorithms, because people, you talk about hiring cases, people use those things. And you know what, they're just as discriminatory as the people who write them. So that's a problem. If you're an employer and you use those, you know, those algorithms don't save you from discrimination complaints. And I think you have to be careful with those things, because when facial recognition software first started coming out, a lot of people, a lot of big companies jumped on this. They saw this as the wave of the future, and most all of them today have backed out because what they found is that facial recognition software doesn't recognize faces of color very well. It's because the prompts that are put into the algorithm are for faces that look like mine, right? They're not for faces that look like somebody else. And so the algorithms are not necessarily non-discriminatory just because somebody says, well, a computer's doing the hiring, so you don't have to. It doesn't work that way. If you buy it, if you use it, if you rent it, if you subscribe to it, it's yours, and you become responsible for the outcome. So you see the agency kind of getting involved in these things, and that's going to shift. The commission will move in the direction that that particular commission wants to go. And I can't remember the last time they did that strategic plan. I want to say it was maybe 4 or 5 years ago, but I do believe that it's up for they're up for a new strategic plan. I want to say in 2022. So they're doing their homework now to figure out where they want to go with that.
So you mentioned that you retired from the EEOC, started your own consulting business. So you do training. And there are a lot of organizations that need training, especially organizations that need to go outside for training. Can you kind of expand on when, knowing that the individuals watching this are managers, supervisors, HR professionals, when should they definitely go outside the organization and bring someone in to train on these topics?
I think it just depends on the organization. I mean, I don't know that outside is always important. I think what's important is that you have a good trainer, right? So that you have somebody that knows what they're doing and can present the material in a way that makes sense or is conceptual for the people that are watching it. So sometimes you have good in-house people that are really good at that kind of stuff, and sometimes you find that we're doing the training and people are reading books, they're looking at their phone. We just can't seem to. We don't necessarily have the subject matter expertise to train in a particular topic, or it's just not something that we're doing really well. Or sometimes we talk about maybe it is necessary to go outside, especially if you're HR. Our managers have started to tune us out, right? Because if you'll find out when you get into HR is that, you're the evil person that if you just didn't exist, those managers could accomplish wonderful things, right? I think if anybody's ever watched this show, The Office, and Michael Scott's relationship with Toby Flenderson, you know exactly what I'm talking about. If those darn HR people would just get out of my hair, I could do wonderful things. I mean, forget the fact that the HR person is trying to save them from being sued, but they're always seen as kind of the bad guy. So a lot of the times I get brought in because it just helps hearing it from somebody else, right? I think maybe sometimes managers think that, well, HR person saying this, it's self-serving, right? The manager never thinks that they're self-serving, but they think the HR person is self-serving. So sometimes I think it's helpful to bring somebody in to say, yeah, I've done this for 30 years. And I can tell you, they're just trying to keep you from losing your job. Because if you're successfully sued, they will fire you, right? So yeah, I think that those are kind of some reasons why that people bring in outside trainers.
I would think that trust would have something to do with that too. We're talking about the potential reasons why individuals might file a claim. If there's a lack of trust from the employees, I would think HR or in-house trainers is probably not the best way to go.
Well, I think ultimately you have to develop the in-house trust. And I think, when I do training on culture, I always tell managers that 0 complaints is not the goal. And I know that seems weird because complaints are negative scores, but not when you're talking about your internal complaint processes. You want them processes that are trusted. How do you know they're trusted? People are using them. Studies show that I'm not making this up, 70% of people who feel like they've been harassed at work never report it to their employers, 70%. So that means that when employers, what's the first piece of data employers always look at to see how they're doing in workplace behavior issues is what? How many complaints are filed? That's bad data. So it's necessary to, from the top down, to create a culture in which there is trust that within the organization, that the organization takes seriously these kinds of issues. Not that they're always going to side with the employee. That's unrealistic. I don't think employees even think that, but it means that they will take a serious look at it. It means that they really are interested in making sure that their employees are safe and in a working environment which they can succeed. I think more and more, especially with the tight labor market these days, and the labor market is brutally tight in certain industries, that employers have to do that. They have to make sure that they're developing and keeping talent, and you don't keep talent if you don't have a good place to work.
I agree. Employees definitely need to feel like they've been heard and they're treated fairly. I mean, I think that most issues can be resolved if they feel that,
Right.
which goes to trust. Absolutely.
Right.
So to kind of wrap things up, knowing that these are supervisors, managers, HR professionals, what resources do you think they should use to further educate themselves on this topic?
I think it's the EEOC itself offers a lot on their website. It's not easy to find. It's kind of it's a website created without a lot of resources. But if you dig hard enough, you will find a huge amount of guidance on all kinds of things. We're talking about race or disability or hiring or discipline, you name it. One of the things that the EEOC has, and it's not advertised a huge amount of it, I think it's super helpful, is they have this thing called the Small Business Liaison. And I was the Small Business Liaison for the Dallas district. And what that is one person in each district, and their email and direct phone number are published on the website, which is a little spooky, because nobody does that, but you have it there. And that means that you can call that person directly. You don't have to go through people that are reading scripts at you. You just get a hold of that person directly and they will answer your questions. You don't have to be a small business in order to use that, but you're actually talking to someone that knows what they're talking about, right? So when people would call me, I would say, well, this is how the law looks at these type of situations, and this is how the EEOC looks at them, and here's some things you need to think of. It's not advice like legal advice, but it is some things that might help direct you to where you need to be thinking or what you need to be thinking about. So I found that to be a helpful resource. There's I think if you're at an organization maybe that doesn't have a well-developed HR department, I would get involved in a SHRM, or Society for Human Resource Management chapter. They are great resources for education and networking and finding out about all the things that you're probably doing wrong from an HR point of view that you really need to fix. So I think those are really wonderful resources as well, in order to get the information you want, and also just the training. If you're unfamiliar with certain aspects of the law, there's all kinds of webinars out there now. There's all kinds of training out there that a lot of different sources are providing, whether it be law firms or Rodney Klein EEO Training, or other people that provide that will give you the information that you need in order to be successful in what you're doing from an organizational point of view.
Okay, any final thoughts for our students, skill development or career development?
Yeah, when we're talking about EEO, I didn't have an EEO background when I got hired. So if you're interested in, let's say, positions with the federal government or with the state, or maybe with like the city of Austin has their own office as an example, I don't know that there's a particular background that you need to have in order to get one of those positions. I think in a sense, you have to be good with analyzing. You have to be good. You have to be open-handed with information that you get. You have to be fair-minded. Those kinds of things are more of those soft skills, or those intangible skills. You have to be able to work in inventory, and you have to be able to work under difficult conditions, because the truth is that no matter what you do, somebody doesn't like it, right? So if you find discrimination, the employer's not going to like it. If you don't find discrimination, the employee's not going to like it. So you have to be able to work within that environment. I think as far as maybe not going into that kind of work directly, but being in management, you know, it's interesting. People are selected for management positions because, well, you know, they're just really good at what they do, and they've shown a degree of accountability. But how many people are selected for their supervisory management experiences because they have a lot of knowledge of EEO? Nobody, right? So it's important that when you get into those positions that you plug in to whatever resources the organization has internally or maybe externally to learn about basic EEO function, because you're going to need it if you're working with people. And because I read someplace that when you're a first line worker and you're a frontline worker, mostly of what you use are cognitive skills, right? Problem solving skills. And that's what you do mostly. But when you move up within organizations, you find that you use fewer of those cognitive skills and you use more of emotional social skills, or the skills that you need to work with people. And working with people is not easy. And I think that you can't ever get enough information about that, and you can't ever stop learning, because people are fascinating, but they can also be infuriating. And to get the most out of your people, because that's kind of what you're paid to do, it requires a great deal of work and maybe rethinking how you approach situations and how you approach individuals.
Okay, that was awesome. Thank you so much. I really appreciate you talking to our students.
Oh, you're very welcome.